Last case on the docket is Shank and Shank versus Lake County Property Appraiser.
Good morning, Your Honors. My name is Edward Jordan. I have the pleasure of representing Brian and Elaine Shank, who are the appellants in this matter. You will understand or know that this case comes to the court on the Lake County Circuit Court judge's entry of a order dismissing the case on a motion to dismiss for lack of subject matter jurisdiction. Specifically, this case went to the trial court on a protest of a denial of the appellant's application for an agricultural exemption of their property in Lake County for 2006. The final decision that starts the clock for filing under Section 194-171 was rendered on March 9 of 2007. That's from the Adjustment Board, and they denied finally the application. The statute 194-171 has jurisdictional requirements that must be followed, specifically that you file your action within 60 days of the final decision. So that if you look at the March 9, 2007, the action had to be filed by May 8th of 2007, which was the 60th day. May I say that the record on appeal indicates that the complaint was filed on May 8th, 2007, and there's no question that the 60-day time frame was met. Secondly, the statute provides in paragraph section 3 that the person protesting the denial must file an amount of taxes that it feels in good faith is due and owing for that year before filing the complaint. And so the record is clear, and there is nothing unverified, nothing verified that takes away from the well-pled allegations in the complaint, paragraph 11 of the complaint, which says that on May 4th, 2007, that would be 4 days before we filed, the plaintiffs filed their payment, which the complaint alleges was their good faith acknowledgement of what was due and owing. The next requirement in the statute is that the tax collector must, or I'll actually use the correct word, shall issue a receipt for the payment, and then once that receipt is issued, the taxpayer must file the receipt with the court. The obligations for the payment of the amount that the taxpayer believes is good faith due and owing, and the obligation of the tax collector to issue the receipt, both come with the legislative words shall, which this court and others, including the Supreme Court, has found to be non-discretionary.
Well, the statute also says the receipt shall be filed with the complaint, right?
Yes, it does.
And you didn't do that, right?
Well, then, in that regard, the second DCA, the only court construing that language, has found that the issue of non-filing the receipt is not a subject matter jurisdictional issue. That's in the Micos case, because it is the payment versus the actual filing of the receipt that is important, and that case stands on its own without any court, without having any questioning authorities from any sister courts.
Well, but you're asking us to construe the statute other than literally, right? You want us to rule that the receipt shall be filed with the complaint means that it shall, unless there's a good reason why it isn't.
Well, Your Honor, I'm not asking you to construe that at all that way, because the Micos decision has said that it is not a condition precedent to filing a lawsuit. It does not make that dismissible under the Micos decision, and that's been cited in the brief. What I will say to you is that you can't do something that you don't have to do. If you don't have a receipt to file, you can't file it. And the Micos decision made clear that the non-filing of the receipt at the time of the filing the complaint is not a jurisdictional default, which renders or which excuses the court of having any subject matter jurisdiction.
Well, is it subject to motion to dismiss for failure to state a cause of action?
It's neither, Your Honor. Micos decision has stated that.
Well, let me just tell you something about the second district. That's a different district over there. We're going to take a fresh look at the statute. So let's talk about what the statute says. I mean,
right.
Would the property appraiser have a valid basis for asserting that your complaint failed to state a cause of action? Because you can look at the four corners of the complaint, you can look at the attachments, and you can see that the receipt's not attached, and that it's subject to dismissal, maybe even without prejudice to cure it.
Arguably, if you look at it from the strict reading of the statute, then yes, but that would ignore the only case or court construing that language. However, at the same token, if you construe that sentence requiring us to file the receipt, then you go to the preceding sentence, which says the tax collector shall issue a receipt. So now, if we don't have a receipt and the tax collector has materially breached his statutory duty to render a receipt, we're excused, just like a material breach of contract. We're discharged from having to do something that we cannot do. And that's why the Micos decision has made that rationale.
For the payment, the tax collector shall issue a receipt for the payment.
Yes.
Refers to the good faith payment, right?
Absolutely correct.
Okay. Now, I mean, I guess counsel would argue that the tax collector's not under any obligation to issue a receipt or a payment that the tax collector is unaware is a good faith payment.
The statute doesn't say that, and what happened in this case is that we filed our payment, which states, and it's record page 94, paying under protest, reserving all rights. Now, what the tax collector would want this court to believe is that you have to have some sort of magical language to put the tax collector on notice. There is no requirement in the statute that we have to use some magical language. And here's the paradox, or the unanswered questions, if this court would find additional language in the statute to require that type of special language. Number one is what must be used. First of all, the statute says when you're contesting a tax assessment, you must do the following. What is the difference between contesting and protesting? We put on our payment paying under protest. Number two is how must that notice be tendered? Must it have certain language that the statute doesn't contain? Must it use the very verbatim words, good faith payment? And must it be witnessed? It must be notarized? How much can it be verbal? There's no language in the statute that allows one to have clear guidance on what would be required. So if the court...
Jordan, what is the purpose of the legislative purpose for the precondition that's contained in the statute?
I believe the precondition to pay the amount that you believe is in good faith, due and owing, and also to not become delinquent subsequently, is that therefore at least the taxing authority collects that which is the tax collector believes is due, and then the amount contesting will be the only issue before.
We don't want the government to go broke.
Absolutely.
While it's tied up in litigation, right?
Correct. And in this case...
So why shouldn't at least the burden on the taxpayer be this, that if the taxpayer does not have the receipt because the collector made some mistake and the property appraiser comes forward with a motion to dismiss, that the taxpayer has some burden at least to go and correct the situation by communicating to the collector that, okay, this was intended to be a good faith payment, now give me my receipt, and now I'm going to file it by way of an amended complaint.
Love to do it. Love to have done that. However, even the tax collector in this case, even the appellees will have presented to the court and in their motion, citing the Clark v. Cook and the Wilkinson matter, that for whatever reason, if you don't meet the 60th day, you cannot breathe life back into a non-compliance. One was it was lost in the mail, and the other one was...
It's not your position that you can, now that the tax collector erred in his or her interpretation of what the purpose was for the tender, that you can go from the beginning to the end of the lawsuit without ever having to deposit the money. That's not your position.
No, because we had deposited the money.
You stand ready to pay the money as long as the court lets you as a precondition to proceeding on the merits.
Absolutely. And when we made the payment, what is important is, and the reason why I went through the timeline, the briefs established, that it wasn't until the 61st day, May 9th, that we received notice. The tax collector waited until the 60-day period had expired before giving us notice. Now, it had 4 days because we remitted our payment on the 4th. May I say to the court that the complaint alleges that. The payment, page 94, shows that. And number 3, the motion to dismiss filed by the appellees establishes that on May 4th we remitted our payment. So at the status of a motion to dismiss, the collector had 4 days to notify us, but waited until the 5th day after the time frame had elapsed. So anything that we would have done would have been a useless act. May I also say to the court, which I think is very important here, is that the court made findings of fact as to what the appellant's intentions were. It specifically noted in its order that the appellants failed to indicate their intention to the tax collector. Well, then that requires the trial court to construe the language paying under protest, reserving all rights. There's the unverified motion. We have our payment showing paying under protest, reserving all rights. What were the intentions of the appellants? There's no evidence on that, and even if it were, the court couldn't construe it at the motion to dismiss level.
Let me ask you this. You know, from your point of view, the statute provides that you have to do at least 2 things that are jurisdictional.
Yes, Your Honor.
1, you have to file within 60 days of the date of the assessment being certified for collection, and 2, that you paid the amount which your client believed in good faith was due and owing.
Yes, Your Honor.
So from your perspective, you met both requirements, therefore it's error for the trial court to dismiss.
And that has been alleged in the complaint.
Okay,
Yes, Your Honor.
I understand. Now, let me ask from the tax assessor's perspective. They have a rule that says that they may not accept a partial payment. They also have a requirement by statute that they are to accept a payment made in good faith under the statute. How are they to determine which duty they have?
I would say to you the same way the appellants or the taxpayer is. We give a notice, we make our payment. The tax collector has our address, has all the billing information, and if one would say the taxpayer has an obligation to notify, then the same, if there's a question on intent, then the tax collector should have the same burden to find out what our intent was. In this case, it's just as easy for the tax collector to look at a payment that says paying under protest, reserving all rights, and say, whoa, what is this?
Well, actually, paying under protest is kind of the opposite of good faith, because it means you don't even think that amount was owed.
We're contesting the amount. We're paying under protest and reserving all rights.
But are you suggesting the tax assessor, for any check it receives which is less than the full amount, has an obligation to contact the taxpayer and say, did you mean this as a good faith payment, or did you intend this as a partial payment?
I'm not certain what the statute requires, and if there's an ambiguity under 194.171, if this court finds to be an ambiguity, then this court would be finding the statute unconstitutionally vague, because you would be putting a burden on the taxpayer, that is not found in the statute, and if we don't meet the magical language or do something that is not in the statute, then our rights are forever barred. So if you're asking me what the tax collector must do, it says shall issue a receipt. It says to the taxpayer, shall make a payment. We did tender the payment, and the tax collector did not issue a receipt, refused to issue a receipt. So having said that, I understand the paradox that you present, but both are non-discretionary acts by each party, and neither, the statute does not require an explanation of our payment to the tax collector. If it did, then that would have to be set forth as to what and how and when the explanation would have to be and what form it would have to be in. There's nothing there,
Right,
so
but
we're left.
if we wrote an opinion which agreed with you, what do we tell the tax assessor on how to handle this type of situation where they have an obligation to not accept the payment, but they have an obligation to accept the payment as well?
It could issue a receipt, as it's required to do, and then challenge the payment if it's not contested within 60 days. An example would be here. If we remitted our payment on, say, March 31st, and we did not file our action on the 60th day, then the tax collector could challenge the payment and refund it back and say you've not met your 60-day rule. This is only a 60-day window. Secondly, what the tax collector could simply do is challenge the payment even in the lawsuit as being improper, not a good faith amount that is based on any type of facts, although the complaint here alleges what we based our payment on. So the tax collector has 60 days. It can issue the receipt, accept the money so the government doesn't go broke, and if 60 days a lawsuit is not filed, then the tax collector can say, we cannot accept this payment, we're refunding it back, you must pay the full amount. That's what the statutory scheme provides. Here, what the tax collector did was just simply not accept it, wait until our time had expired to properly pay or meet whatever magical language they wanted, and then at the end of the day, we're stuck having no ability to resurrect a perception of noncompliance when we complied with the letter of the law.
All right, so you're saying the tax assessor, if it got a payment, a partial payment, one day after the assessment was certified as being due, that they would then have to wait 59, 60 days before they could return it to see if there was a lawsuit filed?
It would issue a receipt, and note that it could do whatever it wanted to on the receipt, but it could issue a receipt, and then if no action was filed on the 60th day, then either they could state that it was a partial payment unacceptable, or the tax collector for 59 days could write a receipt and say, please explain whether or not this is a good faith payment or a partial payment. We had nothing from the tax collector to alert us that our payment was not accepted within the 60 days, even though it was timely remitted. And so now our obligation to remit a good faith payment or to put on some magical language on the check, we can't do it. It's under the case law, we don't have the ability to correct the error if there's a perceived error because the tax collector did not issue the receipt. So we're stuck having no rights because the tax collector has construed the statute incorrectly. That is, I can't take a partial payment. Well, in this case, what is very important here is that the explanation from on the non-acceptance of the payment says Florida statutes do not allow partial payment. It didn't say unless this is a payment under 194.171. There was no any attempt to determine what our payment was. I would say this, and I'll reserve a couple minutes if I may. What is important here is that if the court is going to put a burden on the taxpayer beyond the language of the statute, it makes it unconstitutionally vague. We think it's clear. We don't think it's unconstitutionally vague. But if this court's going to put some burden and it's going to add to the statutory language, then we're left to guess and we have no rights.
Did your original complaint explain the existence of the receipt?
It did. We stated in our complaint that a receipt has not yet been issued. Thank you.
Got about a minute 40 left.
May it please the court. I'm Gaylord Wood of the firm of Wood and Stewart in Bunnell, and my partner Jordan Stewart is with me today. We represent the only appellee in the case, who is Ed Havill, the Lake County property appraiser. And there's been a lot of talk about Bob McKee, who is the Lake County tax collector. He is not a party to this action. even though he is a proper party, he could have been sued as a defendant. He was not. Therefore, he is not a party to the case. I think that the court can take judicial notice of the fact that the Lake County tax collector does a whole lot more than simply accept property tax payments. They're the agents for the state of Florida. They sell all the motor vehicle tags. They sell hunting and fishing licenses. They do quite a bit more than...
Is the tax collector the gatekeeper for property owners' claims that the appraisal is incorrect, unfair, the assessment, I guess?
No. In a lawsuit under 194.171, the only mandatory defendant would be the property appraiser, and it's not an exemption, it's an agricultural
Well, does the tax
classification.
collector have the unbridled discretion to withhold the issuance of a receipt for a good faith payment?
Well, if you look at the exhibit to what was filed as the notice of filing refusal to accept good faith payment, which finally came to light in January of 2008, the check simply, and there are people in the common law movement where everything is reserving all rights, paid under protest. The words paid under protest really come out of the negotiable instruments law and now the Uniform Commercial Code. It says,
I appreciate what I think you're arguing here, but I'm not sure that you appreciate my question, which is, in the abstract, under this statute, does the tax collector have the unbridled right to withhold issuance of a receipt when a taxpayer seeks to challenge an assessment and submits a good faith payment?
I think that the tax collector's responsibility is that when a taxpayer, particularly when the taxes are delinquent, they went delinquent on April 1st, 2007, according to Chapter 197.122. And I think it is incumbent upon the landowner intending to make a good faith payment to identify his desire to the tax collector.
Okay, let me try that one more. I'll take one more crack at the question. And,
Okay.
And if you don't want to answer me, I guess that's your business. But it's obviously a concern of mine, and that is, let's say the tax collector is a Seminole, a Florida State graduate, and the taxpayer submits a check with one of those gator heads on it, and the tax collector decides that he's not going to accept payments written on checks that have a gator logo on them, and decides to send the check back or not issue a receipt. Can the taxpayer still protest the assessment if the taxpayer makes all those allegations in the complaint?
According to the statute, it is the obligation of the taxpayer to pay at least the amount of the taxes that are in good faith admitted to be due to the tax collector. It doesn't say tender, and this is what counsel would like the court to rewrite, to add words to the statute not placed there by the legislature. The legislature has a requirement of payment, and it doesn't say tender, it doesn't say good faith effort, it doesn't say college try.
So the statute says you got to attach your receipt.
Yeah.
There's no defense to that. You either attach the receipt or you're out of court.
Absolutely. There are three
And it doesn't
things.
make any difference why you don't have the receipt. The tax collector could have, in bad faith, decided not to issue the receipt because he didn't want to do it, or could have been arbitrary, or it doesn't make any difference, right?
I think we have to presume good faith performance.
Well,
of their
suppose the
duties by
taxpayer
public
alleges
officials.
bad faith. Suppose the taxpayer alleges that they're just being arbitrary, or they're wrong in not issuing the receipt.
Well, they didn't. In fact, the complaint.
But I'm just asking in the abstract, counsel.
Right.
I'm not sure. In other words, are you insistent that we interpret this requirement absolutely literally without without any deviation from the literal language of the statute.
This court has held on numerous occasions that the courts are not free to add or take away words to a plain statute not placed there by the legislature, so my answer would be you cannot modify
So if the tax
statute.
collector withheld issuance of the receipt for reasons that are wholly arbitrary, the taxpayer does not have a remedy to challenge the assessment.
Number one, it's not our case here, and number two, we are not counsel for the Lake County tax collector, so I don't think I can answer a question
All right, that's fine.
on behalf of the tax collector. Now,
Now, but let me make sure I understand your position. So is your position if the taxpayer pays the amount and they put on the check, our good faith payment, we plan on suing, because we disagree that the whole amount assessed is due, and they give it to you the day after the order from the board below, and the tax collector sits on the check for 65 days, that they're barred from bringing any action. Is that your
First of
position?
all,
based on what you say is a literal reading of the statute?
the statute, first of all, the money is not paid to the property appraiser. In other words, the property appraiser
Brought in a check to the tax collector on day one, and the tax collector sits on it for 65 days.
I think that it is still the obligation of the taxpayer to either pay in full and get a refund or make a good faith payment of at least the amount they admit to be due. Knowing the statute countenances no exceptions.
Well, I'm
in
saying
fact,
they've made a good faith payment of the
well,
amount.
they didn't make a good faith payment.
no,
they made
let's-
a tender.
Under you said that the receipt is, are you saying it's jurisdictional?
I'm saying the legislature and the Florida Supreme Court both say this is a jurisdictional statute of
Where in the
non-claim.
statute does it say that the receipt is jurisdictional as
Subsections.
opposed to payment and the timeliness?
Subsection 6 of the statute.
Right, but where does it refer?
It says the requirements of subsections 2, 3, and 5 are jurisdictional, and no court shall have jurisdiction until those requirements are met. It could not be more clear.
So that is your position that Micos is wrongly decided?
Absolutely. The court there, now, the difference in the Micos case, the taxpayer had actually made the payment to the tax collector in Sarasota County. And for whatever reason, and I suggest it's because this is an area of the law where this statute is a minefield for the general practitioner, the attorney drafting the complaint didn't attach the receipt. It came out that, yes, the payment had been made, and so the court said, well, then I guess the receipt isn't jurisdictional.
All right, so back to the question that Judge Torpey is asking, and I'm asking now, if the person on day one gives a check, says this is not the full amount, but it's the amount I believe in good faith is due and owing because I challenge, the assessment, and delivers that check to the tax collector on day one, and the tax collector sits on it for 65 days and does nothing, are you saying that the taxpayer is prohibited, is barred jurisdictionally from bringing any action to challenge the assessment?
Well, first of all,
I'd say calls for yes or no.
well, no, it
No,
doesn't.
I want a yes or no.
I have to emphasize the chronology here. These are taxes for the year 2006. The tax collector's window opened on November 1, 2006 to begin collecting the 2006 taxes. They became delinquent on April 1, 2007. So the taxpayer had the month of November, December of 06, then January, February, and March of 07 to make their good faith payment.
All right, payments tendered March 31st.
Okay?
All right, under my hypothetical,
And
is the
accepted?
taxpayer jurisdictionally barred from bringing any action challenge the assessment if the tax collector sat on the tendered check for 65 days?
Well, it wasn't 65 days. It was 5 months.
My hypothetical,
Yeah, okay.
yes or no?
There's no way that the taxpayer, that the court has jurisdiction without meeting the strict 60-day requirement and the good faith payment requirements of subsection 3, period.
Right, but they've made the payment, they've done it they've made
Right.
the payment in 60 days, but tax collector refused to cash the check for 65 days. You're saying the taxpayer is is barred from bringing the action?
It would be, the court, if in so holding, would be inserting words in the statute not placed there by the legislature, which you have held the courts are not free to do.
All right, so you're saying the statute in that scenario would say taxpayer loses?
It's the same problem that an appellant has when on the 31st day after a judgment is rendered, come to this court and say, or come to the circuit court to file a notice of appeal and say, well, you know, the FedEx plane crashed and so my notice of appeal was late. You know, the Supreme Court called this statute harsh. It is harsh. The revenues of Lake County, the school board, the taxing bodies, the legislature has gone to extraordinary means to protect them. And I would suggest that if there is to be latitude made in this statute, it must be made by the legislature and not by the courts.
So under your position, even if the taxpayer paid the entire amount of the taxes, but they didn't give him a receipt for it, he's out of luck. He can't then contest the assessment. Is that your position?
That's what it says. If he made the payment and it was accepted by the tax collector and he didn't file the receipt with the complaint?
Well, if he filed it, it was accepted, and the tax assessor refused to give him a receipt. The tax collector refused to give him a receipt. He is without a remedy. Is that your position?
That's what the statute says.
So that's your position?
Sure.
As long as we're dealing with the literal reading of the statute, is there anywhere in the statute that it says that in making the good faith payment, the taxpayer will include a letter or an indication on the check that this is a good faith payment?
Well, I think that when
is there anything in the statute that says that?
Yeah, it says that the taxpayer shall pay at least the amount in good faith he admits to be owing. And so I think he must notify the collector. This is not a partial payment.
Where does it say that in the statute that he's to provide that notice as well? He
either has to pay the full amount or the amount in good faith he admits to be owing. And I think that particularly because Rule 12D 13.002 specifically prohibits the tax collector from accepting partial payments after the taxes were delinquent, and in fact the notice that was with this shows that a tax certificate would have been sold on June 1st of 2007. It was incumbent upon the taxpayer to let the collector know this is not just a partial payment. This is a good faith payment because we intend to file suit. And
that part of the statute we should imply, even though it's not literally in the statute?
It's not implied. The statute says that he shall tender at least the amount in good faith admitted to be owed.
He's alleged that he did that. So you in your answer brief...
It does not say tender. It says pay. He did not pay that. So he missed the first part of the statute. And I would like briefly to comment on the argument that the Shanks make that says that the court, in deciding a motion for lack of subject matter jurisdiction, is limited to the four corners of the complaint. And under Rule 1.140, there are matters in abatement and matters in bar. And the cases which he cites are all cases involving a motion to dismiss based on a complaint not stating a cause of action, which is a motion in bar. In a motion in abatement, the court can look at matters outside of the four corners of the complaint, such as the unusual document which counsel filed in January of 2008 attempting to explain the quote, notice of filing refusal to accept good faith payment, which didn't come to light until January of 2008. And so it is not true that a court is limited to the four corners of the complaint. In fact, in the four corners of the complaint, they said we've complied with all conditions preceding, which was not true. We think that in order for this court to grant relief to the Shanks, you would have to overrule and recede from your decision in Suber versus Pultz. That was a suit which was seeking a writ, an extraordinary writ of prohibition to prohibit the circuit court in Seminole County from proceeding with the case where the taxpayer had not paid a good faith payment in an agriculture case and filed a receipt with the complaint. And I cannot distinguish that case from this one. It's the taxpayer did not do what the statute required them to do, and you correctly issued the writ of prohibition and said that the case cannot proceed. That taxpayer, because of their failure to comply with the statute, was left without a judicial remedy. We think that the same thing, same results should apply here.
Was that a case where the payment was refused, or the issuance of a receipt was refused to be given?
I don't remember. I don't remember the facts of the Pulse, Suber v. Pulse. I think they just didn't make the payment. I think they filed suit.
Well, then why would we have to recede from that case to come up with a rule? In this case, it says there's a difference between not tendering the payment and the payment being refused.
Because the statute doesn't say tender. The statute says pay. We think that's for you to rewrite the statute to say tender would create uncertainty in this area of the law. Right now, it's a bright line test. You must pay to the collector at least the amount you contend to be owing.
So instead of a check, if they had dropped off cash, that would be payment, even though you sent it back later?
Well, we didn't send it back. The collector, who's not a party to this action.
All right, would they have paid it if they dropped off in cash instead of a check? And the collector took it and then mailed it back?
I don't know what the tax collector's policy is. I will assume that they would accept cash. I don't know why they wouldn't.
Presumably, if they thought it was a partial payment, they would.
But if they thought it was if there was no indication that this was intended to be a good faith payment, and when someone brought in $800 when the amount of the tax bill was $1,402, and they only paid $894, I think the collector, with no indication of what this was, even if the taxpayer said, "I'm paying this under protest and I am reserving all legal rights," if that's all the taxpayer said, I think the collector would be acting properly under 12D 13.002 and saying, "No, that's not enough money. You need to come back when you've got the rest of it." And if at that point the taxpayer said, "Well, this is intended to be a good faith payment," the collector would say, "Well, why didn't you say so?"
But we're still not going to give you the receipt, so.
And at that point, they'd get the receipt, and the case would proceed. But we think that the circuit court was well within the record, well within the statute. This statute is one of those unfortunate rocks and shoals. There are only two statutes of non-claim in the entire panoply of the legislature. The other one is the one that says that you must file suit where you're suing a decedent's estate. You have 2 years from the date of death in which to file.
Any indication in the record of any other circumstances where a partial payment is made with a notation that it's under protest, that it's ever anything other than this good faith deposit?
There's nothing in our record. The only document we have is this unusual notice of refusal to accept good faith payment. We denied the fact that a good faith payment had been made when we answered the complaint, because we did not see a receipt. It wasn't until January of 2008 when this document surfaced, and even though we were in the case at the time, it was supposedly served on a Frank Royce, who is the chief deputy in the Lake County Property Appraiser's office. It was very unusual. So we respectfully suggest that the trial court's order be affirmed.
Thank you, counsel.
May it please the court, and I know I have very little time, but I do want to...
I don't have any other questions of you.
I'm sorry?
I just said I don't have any other questions of you.
May I just remind the court that paragraph 11, because there's a distinction that's being raised between tender and payment, paragraph number 11 of the complaint says, on May 4th, trustees timely paid to the tax collector, and then it attached a copy of the exhibit which had paying under protest. The question of what was intended by payment under protest is a factual question, not challenged by anybody. There's nothing of record to say it wasn't a good faith payment. And number two, I understand that this court has asked the question in a hypothetical with regards to what if the receipt wasn't issued. And the fact of the matter is, a literal reading of this statute requires that it is non-discretionary, just as our payment is non-discretionary. So what the appellees are asking this court is to insert language in that is not in the statute. Without having that guidance, the statute then becomes unconstitutionally vague, and this court is required to construe the statute as best it can in a constitutional context. I would lastly say...
That constitutional argument made below?
Yes, it was. I believe it was made below in the motion. I'm not certain. I shouldn't say that it was or was not. I apologize for the court, but it was made in the briefs. The last question is if we're supposed to identify, how do we do that? If the statute is unclear, we don't have any language in the statute to tell us how we identify it as a good faith payment. We ask the court to just return this back for a factual determination of what was meant by our payment.
Thank you, counsel.
Thank you, counsel. Thank you, Your Honor.
Court will be